Mentioning one cancellation of bill, my lord.
Lord, may I, with your lordship's
Yeah,
permission,
to mention one matter of this application has been filed for modification of judgment dated 6 February of 2023, which passed by this honorable court. This application has been filed because your appellant is suffering from chronic heart disease and he is not
My lord,
inclusive.
Mr. Patwalia, my lord, is appearing virtually, my lord, but he would mention a matter before your lordship, my lord.
Lord, that matter is coming up tomorrow. That is that setback from the Supreme Court matter for that revision for quashing, where the lady had got a job. Your lordship had been pleased to keep it for tomorrow. I have some personal difficulty tomorrow. Can it be a week later? We have requested the PP. He has no difficulty in case your lordship can accommodate.
Mr. Patwalia, if both the parties agree to a date, we will fix it on that.
My lord, the public prosecutor.
Next Thursday, my lord. Next Thursday.
Which date?
My lord, next.
Who is for the public prosecutor?
My lord, in the morning itself, my lord, we have.
At least someone should be there so that. All right, Mr. Patwalia, let your junior and the public prosecutor's office agree on a date. We will fix on that date.
Grateful, very grateful, very grateful, very grateful, very grateful.
We may be keeping it at 2 p.m. or something like that.
Whenever your lordship, whenever, very grateful.
Yeah,
Next Thursday, we have requested. So anything, any day. Very great.
Prefer it at second half of the day, so that
I'm okay for the morning also, my lord. There's no problem on any Thursday on the morning.
I have a little bit of a problem with the morning.
Yeah, no difficulty, my lord. Second half is equally good. No difficulty.
Dispose of the miscellaneous matters first.
No difficulty, my lord. Second half on any day.
Take some time in hearing, right?
All right. All right. Yes, it will. It will take. It will. Yeah.
So what we propose to do is keep it at around 2 p.m.
All right.
Both of you agree.
All right. All right. All right. Grateful. Grateful.
Wednesday or something?
My lord, next Thursday, my lord, subject to your lordship's convenience, my lord, is what Mr. Patwalia was requesting, my lord.
Thursday.
Thursday,
we have the Ponzi cases from 2. Okay. All right, we will keep it between 2 and 3 for an hour. The Patwalia, an hour.
That's fair enough. Fair enough. Fair enough. Grateful. Grateful.
You cannot conclude. We'll have to keep it on another day.
No difficulty, my lord. No difficulty. It's a pleasure. Grateful.
2 p.m. Thursday.
Deeply grateful.
Your lordship, mention one matter: admission of appeal, inclusion.
No, lucky.
Bail in connection with appeal, my lord.
Lordship, may I be permitted to mention one matter: bail in connection with appeal.
May I permitted to mention one matter, my lord? Contempt of the court, my lord.
Contempt.
Contempt, my lord. Of this court.
Now what?
on an item
They're supposed to file a report.
Well, it's under Mines and Minerals Act. Well, royalty amount has been determined. Its royalty amount is 12,54,000 and the price for mineral recovery is 18 lakhs and all.
May I take instruction and come back?
No instruction.
Madam, because,
Copy is given adjourn 1 week.
Madam, may I have a report of the
Copy of the report is given. So, follow it. 18.
Other than the report be kept with the record.
Report is given.
Great.
There was a direction to pay 50% of provisional bill. They have paid, madam.
Petitioner has deposited 50% of the provisional bill to the tune of so and so in light of the aforesaid fact and nature of the
Provision,
we are
no, no.
inclined to grant that.
Grateful, madam.
Next.
And লিখে দিয়েছি।
Great.
Madam, for the petition.
Is
My lordship,
yes.
my lordship had seen the postmortem report and asked me to get a second opinion, my lordship.
Petitioner, the in-laws, my lord, husband is in custody. Father-in-law has been granted.
Report is placed on record. Victim housewife, as per the report, victim housewife suffered asphyxial homicidal death at the matrimonial home. Petitioners are the in-laws of the victim housewife. They were present in the matrimonial home at the time of occurrence. In view of the aforesaid fact, no explanation is forthcoming from them. They have not offered explanation with regard to the circumstances leading to the homicidal death of the housewife. Under such circumstances and in view of gravity of offense, we are not inclined to grant ancillary bail to them. Next.
Well, 5, I beg to appear for the petitioner.
For the statement.
It was adjourned on the ground that the petitioner is willing to secure that money because the offense relates to 420-409. Allegation of the de facto is that I, being a field agent, took 4 lakhs something, my lord, from the several person. Thereafter, 1 lakh I repaid. Remaining part I didn't repay. My lord, petitioner is willing to secure the money, my lord, in court if your lordship pass direction upon the learned CGM, my lord.
Petitioner is ready and willing to deposit. Petitioner is ready and willing to deposit
3,33,000.
outstanding misappropriated sum of rupees 3 lakhs so and so.
3,33,887.
Jurisdictional court without prejudice to his rights and contentions in the case. In light of the aforesaid submission, we give liberty to the petitioner to deposit the aforesaid sum with the jurisdictional court. And in the event within 7 days from date, in the event the said amount is deposited, the court shall keep it in an auto-renewing fixed deposit account in a nationalized bank subject to the result of the litigation. In light of the bona fides expressed by the petitioner, which erases out the wrongful loss to the complainant, we are inclined to grant answer. Yes.
I am appearing on behalf of the petitioner. Free fight between the two groups. Charge sheet has been submitted against 7. One principal accused got arrested, got bail.
We have considered the materials on record. Petitioner is not the principal accused. Keeping in mind the extent of complicity of the petitioners in the crime, we are inclined to grant answer. Sure. Next, petitioners. Next.
10, my lord, kindly takes up the matter on Friday. This is from Malda, my lord.
Friday.
Can it be on Monday, my lord?
Monday.
This is my application, my lord. Allegation under section 85, 316, 2, 351, 2, 35 of the BNSS.
We have considered the materials on record. Allegations of torture are general and omnibus. Keeping in mind the aforesaid fact, we are of the opinion custodial torture, custodial interrogation is not necessary, but petitioner requires to cooperate with investigation, meet investigating officer once in a week. Next.
Yeah. 306, my lord. The informant's son and the petitioner one had a love affair, my lord. Subsequently, petitioner's son proposed the petitioner one, my lord. She refused the marriage, my lord, because she's studying college, my lord. Due to that, she committed suicide, my lord.
We have considered the materials on record. There was a romantic relation between petitioner number 1 and the deceased. Subsequently, petitioner number 1 withdrew from the relation. Deceased committed suicide. Petitioners, romantic petitioner number 2 and 3 are her relations. Subsequently, petitioner number 1 withdrew. Deceased victim committed suicide. Petitioners have been it is contended petitioners have been falsely roped in the instant case. Statements of witnesses show victim had petitioners had ill-treated and abused the victim prior to the incident. Victim did not leave behind any suicide note implicating the petitioners. Whether ill-treatment/abuse per se would constitute abatement to suicide may be adjudicated at the appropriate stage of the proceeding. Custodial interrogation for progress of investigation not necessary. Petitioners are entitled to answer. Next.
13, we are saying
Your lordship, this is the second 438 bail application. The second application after the filing of the charge sheet. So,
Subsequent application for pre-arrest bail was rejected earlier on merits. There is no change in circumstance. The subsequent application for anticipatory bail is accordingly dismissed. Next.
big to appear on behalf of the petitioner. My lord, the allegation is preparation for committing dacoity. My name was transferred, my lord,
On record.
from the co-accused statement, my lord.
Of co-accused before police petitioner is implicated on the basis of statement before of co-accused before police officer inadmissible in evidence. Under such circumstances, we are inclined to grant answer.
Grateful.
Next.
Under the Electricity Act, my lord, final assessment is 1,98,000.
Petitioner undertakes to deposit 50% of the bill for final bill for unmetered consumption to the tune of so and so within 7 days. Matter will appear 10 days hence.
My lord, grateful. 10 din par. My lord, I have given the amount. Great.
Item number 16, my lord. I appear on behalf of the petitioner, my lord. Chargeable sections are 498A, 354A, 406, 34. My lord,
As he's the brother-in-law before your lordship, as per section 85 is concerned, in-laws is implicating the brother-in-law indirectly, directly. And as for section 75 is concerned, is implicating the father-in-law, sexual harassment. So directly,
The materials on record, petitioner is the brother-in-law of the victim lady. Allegation against him are general and omnibus. Allegation of outraging modesty is leveled against father-in-law and not the petitioner. Accordingly, we are inclined to grant answer.
noticed complaint 35.
I'm grateful, my lord.
Petitioner, my lord. Section.
We have
Section
considered the
85.
materials on record, allegations of torture, general and omnibus. Custodial interrogation for progress of investigation is not necessary, but petitioner requires to cooperate with investigation for recovery of Stridon article if necessary. 10,230 meet investigating officer Mansina. Next.
My lord, I am for the petitioner.
Lordship, I beg to appear for the state.
Section 85, 103(1) and 34 of the Indian Penal Code, my lord. My lord, husband and two brothers. My lord, entire allegation revolves against the husband. Your lordship, kindly see the charge sheet. Kindly see the case.
Who murdered? Who
After
murdered?
10 years of marriage.
She was found in the orchard in the hanging position, and Lordship, it's manual strangulation. Antemortem
We have
analysis.
considered the materials on record. Petitioner number 1 is the husband, and petitioner number 2 and 3 are the brother-in-law of the victim housewife. It is alleged they have been falsely implicated. They pray for ancillary bail, and a lawyer for the state opposed the prayer. We have considered the materials on record. Victim wife suffered homicidal death at the matrimonial suffered
No,
homicidal
no, in
death.
a garden, my lord. She was with her husband at that time.
She was with her husband.
Yes.
Left from the father's home with her husband to coming to their
Right. Incident occurred in a garden where petitioner number 1 was last seen with the deceased, keeping in mind the incriminating materials collected against petitioner number 1 and gravity of offense. We are not inclined to grant ancillary bail to him. However, however, there is no material to show petitioner number 2 and 3 were at the place of occurrence. In view of such fact, we are inclined to grant ancillary bail to them. Allowed.
Obliged.
Next.
rejected husband.
Lordship, from the possession of the husband of the petitioner, 559 grams of morphine and 53 grams of heroin was recovered. Now, first chemical report for both the sample comes negative. Second chemical report, so far as the 559 grams of morphine is concerned, found negative. So far as 53, Lordship, NCB.
Where? AJ. NCB? Honorable Mitro, learned counsel is requested to, nobody appears for NCB, is requested to appear on behalf of NCB. Who regularizes?
My lord, the Ministry of Law and Justice.
Ministry of Law, concerned officer of the Ministry of Law and Justice shall regularize his appointment.
Well,
Take instruction.
my lord, great.
Monday.
Great.
मैं अच्छे तुम्हारे लिए
हाँ,
ठीक है
Three 420 406 for defector complaint purchaser two vehicle unable to pay the loan amount.
Where is the vehicle?
Is handed over to one Kiran Islam. They made an agreement. Enter money.
Where is the vehicle?
I have no knowledge. Kindly see the FIR once.
We have considered the
No
materials of
no allegation, no money transaction at
the
this.
complainant had handed over the vehicle to the defector to the petitioner.
No, my lord. One Muhammad Kiran Islam is the FIR itself, my lord.
Yes.
My lord, he has conspired with this man, Kiran Islam. My lord, thereafter,
Petitioner contends he is no way connected with the vehicle. Vehicle which had been let out to co-accuse Kiran Islam. He prays for ancillary bail. Learned lawyer for the state submit petitioner and the said Kiran Islam had jointly misappropriated the vehicle.
they broke down the parts of the vehicle and they sell it.
Broken down the parts and sold them. Parts of the vehicle and sold them. We have considered the materials on record. De facto complainant had let out the vehicle to one Muhammad Kiran Islam for value on hire. It is alleged he said Kiran Islam and the petitioner had sold the vehicle, had broken down the vehicle and sold it in parts. Good stuff. custodial interrogation for recovery of the vehicle is necessary. Hence, we are not inclined to grant.
No money has been received by me,
Very
nothing.
good. Next.
Yes,
The petitioner under section 448, 324, 326, 427, 307, 354, 379, 506, 34. Number 12, total 12 number of accused were there accused. Out of 12, 10% has given anticipatory bail by the learned session judge. Number the charge sheet has been submitted. There is no such a grievous heart which
You
required.
tried to hang him.
No, Lordship, there is
have been, my lord, appearing before the, my lord, the injury report before the doctor, my lord.
But charge sheet has been submitted, copy has been served upon the others, but in the 161 and 164, there is no such allegation. Only before the doctor, our name has been given. All other aspects are in anticipatory.
But you tried to hang her.
No, but there is no such allegation in the FIR, my lord, subject to correction, my lord.
But the injury report shows hanging.
Hanging, my lord, perhaps it's says about
what? She cannot go and hang herself.
No, no, hanging of, my lord, as per English, subject to correction, my lord, hanging is suppose, my lord, is finger or like that.
Finger only. Okay. Petitioner submits that they have been falsely implicated. They pray for anticipatory learned lawyer for state opposed the prayer. We have considered the materials on record, including the injury report. Injury is on the right toe, a non-vital part of the body. Under such circumstances, we are inclined to grant anticipatory bail, subject to condition, meet investigating officer once in a week conferred.
Much obliged, not grateful.
Next.
My lord, page 7 of my application, my lord, I have annexed the order passed by my lord. Here, my lord, 2% has been granted anticipatory bail.
We have considered the materials on record. Incident occurred in the course of a free fight and was not a premeditated one. Co-accused have been granted pre-arrest bail. Petitioner stands on the same footing and maybe.
But he's not name appeared in the 161 statement.
What statement?
161 statement, his not name appeared.
Oh,
Next.
Grateful, my lord.
Next time for the petitioner, my lord, dispute arises, my lord, the
মানে বাউন্ডারি ওয়াল মানে ডিমার্কেশন অফ দ্য এগ্রিকালচারাল ল্যান্ড মানে
Injury.
মানে দে মানে দ্য ব্রোক দ্য
You have considered the materials on
Fracture and
record.
scalp injury.
Petitioners assaulted the victim, resulting in fracture of the head and internal injury in the brain tissue. In view of the gravity of the injury and prima facie involvement of the petitioner therein, we are not inclined to grant and suit. Next.
I am for the petitioner. I am for the petitioner, my lord.
Where is petitioner?
My lord, the case started.
Oh, yes, we have seen.
Produced by the concerned police, my lord. They have sent the official.
My lord, my client is falsely implicated by the investigation agency, my lord.
One
The-
second.
Number non-existent, my lord. And from the charge sheet, my lord, it is appearing the FIR number supposed to be 140 2021. 44 of 2021, my lord.
So bring that case, liberty to correct the cause title and cause title in respect of the FIR, in respect of the FIR number. Correct case diary be produced Monday or day after tomorrow?
Monday.
Monday.
Deeply obliged, my
Monday.
lord. Deeply obliged, my lord.
इसको तो legal aid lawyer. Years are you practicing now?
My lord, I have tried to practice here, but I transferred my certificate to Karnataka, my lord.
All right, that is very good. How long are you practicing?
I am started on 2022.
22. All right.
Yes, ma'am.
May please.
High Court Legal Service. Next.
27. My lord, I am for the petitioner, my lord. Allegation under section 103, subsection 1 and 3 and 5 of the Indian Penal Code, my lord. BNSS, my lord. My
Who
lord,
are you?
my lord, FIR lodged against 5 persons, my lord. The dead body was found in a Shobji Mandi of another person, my lord. And the petitioners, my lord, they are protected by police picket by a order passed by one of the coordinate bench, my lord. This is the order.
So now the police brigade will be next. You will be in custody.
Kindly see,
My lord,
my
police
the
brigade is
date of
continuing.
occurrence.
My
The
lord,
date of occurrence, my lord, is 5th of February. The police picket and the order has been obtained, my lord, after commission of the crime.
no, my lord. 3rd of January, I have just handed over the copy, my lord.
But it is his, my lord. This he has not annexed it.
At the point of time, my lord, there is a order copy.
But my lord, sees page 4,
This is the order I have handed over, my lord.
page
3rd
4,
of
para
January.
5.
I just continue. At that point of time filing, I could not able to print out the copy. This is so I have handed over, my lord. Enough.
Let us see the postmortem.
My lord, postmortem is page 35.
All right. Petitioner submits. There is tension prevailing in the locality. Petitioner submits. They have been subjected to. Why you ask for police brigade?
Well, there are 23 cases petitioner filed against the other parties, my lord, including rape cases. There is dispute regarding a land, my lord.
This person against this person's family. Did you file any case?
No. Against this person, the victim's body found in a Sabji Mandi, I have filed cases against them. There are 23 cases.
You have filed criminal case against
Pratap Das and Shubir Das, in whose Sabji Mandi the body was found.
petitioner submits. There is a land dispute between them and Pratap Das and Shubir Das. Between them on the one side, between the petitioners on the one side and Pratap and Shubir Das on the other side. They were threatened by the latter and had to approach this court in WPA number and had to approach this court in WPA 3344 of 2023 for necessary relief. for direction. What order was passed there? Contempt.
My lord, kindly comes to.
What was the WPA order?
My lord, this is for police protection, my lord. They have prayed.
And an approach this court seeking police protection. In spite of direction given by this court by a honorable single judge, no steps were taken and petitioners continued to be threatened. In a contempt proceeding by order dated 3/1/2025, officer in charge, Shantipur Police Station, Superintendent of Police, Nodia was directed to provide police picket outside the petitioner's residence.
Well, the next order is at page 9 of his petition.
However, police picket. Subsequently, he has been falsely implicated in the present case. He prays for anticipatory pay. Learned lawyer for the state draws our attention to order dated to a subsequent order dated 7/2/2025, wherein the honorable single judge clarified that the aforesaid direction for police picket shall not stand in the way of investigation of the present case. We have considered the materials on record. Statement, it is alleged petitioners had assaulted, it is alleged on 5/1/2025. 5/2/2025, petitioners assaulted the victim, full stop. On the next day, his body was found hanging in the land of Pratap and Shubir Das, comma, with whom petitioners have inimical relation. Postmortem report placed before us show the victim had died due to hanging, which is ordinarily suicidal. Full stop. In such, given this situation, it is difficult for us to believe. Given this situation, even the allegation of a prior skirmish between the petitioners and the victim is believed. It does not, the assault perpetrated by the assault by the petitioner cannot be said to be the cause of death. On the other hand, the death occurred in a land which is under the control of Pratap and Shubir Das, who are with whom petitioners have inimical relation. Possibility of false implication on this score cannot be ruled out. Under such circumstances, we are inclined to grant anticipatory.
Grateful.
Petition and next.
I beg to appear on behalf of the petitioner, my lord.
I'm appearing on behalf of the de facto complainant, Your Honor.
It pertains to an agreement of sale where it was, my lord, we were supposed to transfer the flat to the complainant, and accordingly that particular project was not completed back in 2016. Thereafter, we offered a shifting. They agreed. Then in that particular project also, my lord, the work was not done in time. So we offered another project that was ongoing where they have agreed, and then later on they have withdrawn themselves from that particular project. After that, they filed a consumer complaint. In that particular consumer case, my lord, we have appeared. We are contesting there, and internally they were praying for the refund of the money along with cost and other damages. So that particular.
Don't you refund the money?
My lord, the consumer complaint, or else we would have returned it.
Because he filed the consumer complaint, that is why you have not.
It's adjudicated. If my lord so directs, we can, my lord, we can give that amount also, right?
Lordship, I'm the de facto complainant. May I humbly some few
Because we have
facts?
already returned to other peoples also, my lord, who have asked and settled with us. And if they have,
Lordship, the project, Shonaturi project, it was about to build 52 flats there. There was 4 towers, and at the time of booking,
We are hearing an ancillary bill application. All right.
Yes.
If you want the money back, we can request them to consider returning the money.
yes, your Lordship, I
Return the money.
Yes, my lord. By how long? When shall we return the money?
What is the principal amount?
My lord, 21 lakhs.
21
And 10 lakhs to that amount was also from the bank was proceeding the loan.
No,
Only 10
Lordship,
lakhs was paid to us.
total amounting 25 lakh 25,500 something, Lordship. That is my claim, irrespective of the additional interest, your Lordship. That is a
First,
claim amount.
whatever amount you have paid to them, that be returned.
Yes, my
We
lord.
are keeping it 1 week.
My lord, not 1 week. The petitioner's father passed away last Wednesday. My lord.
2 weeks.
2 weeks.
Adjourn 2 weeks.
Lordship, much obliged, Your Honor.
Right, 108 corresponding to 306. Right, your petitioner is a paramour. After 12 years of marriage,
Petitioner is not related to the victim wife. She contends she has been falsely implicated. She prays for ancillary bail. A lawyer for the state submit. Petitioner had illicit relation with the victim's husband. She ill-treated her. As a result, she committed suicide. We have considered the materials on record. Petitioner is not a relation of the husband of the victim. Full stop. She did not reside with her at the it is alleged she is the husband's paramour. Full stop. She was not present at the place of occurrence when the incident occurred. Keeping in mind the aforesaid facts, we are of the opinion custodial interrogation is not necessary and petitioner may be granted. Next.
Yes, Lordship, my petition, Lordship. Section 324, 172.
We have considered the materials on record. Statements of witnesses show petitioner participated in the assault. As a result, the victim lost vision in one eye. In view of the prima facie involvement of the petitioner in the crime and the gravity of offense, we are not inclined to grant action. One by one, you are bringing.
Lordship, allegations under sections 448, 326, 307 of the Indian Penal Code. Petitioner is the son of the de facto complainant. Out of a family feud, the petitioner attacked the de facto complainant, and
Proclamation of attachment order was
talk of
passed by-
settlement is already going on. The de facto complainant is the father of the
The talk of settlement will not do.
Will not.
Petitioner had absconded and has been declared as a proclaimed offender. What is the nature of injury?
Grievous, my lord, assaulted with both him, my lord.
Where?
In
Head. Injury is on the head, that is a vital part of the body.
In that event, if I not press the application.
Scalp injuries.
Scalp. Not scalp.
Not praised. They are afraid of both of you. Next.
I am for the petitioner, madam. The petitioner and others.
Simple. What simple? Give me a moment. Is the food coming? Very odd. Shows the injury is simple. In view of the aforesaid fact, we are inclined to grant answer. You are staying entire day in court?
But I'm for the petitioner. But 420, 120B.
You
But
for victim.
after
Complainant.
after the agreement of sale, but within stipulated period of time, they did not give money. My mother was in hospital for treatment, but I had to purchase the flat. But the original deed has been seized. But that is page number 4.
Purchase the flat means?
But agreement for sale.
Right.
I am the owner of the flat. But mother of my mother, my lord, was in hospital. I was in hurry to sell the flat, but he was not giving. He did not give money within stipulated period of time. As
so, you sold it to another person.
Yes, my lord. I have requested him several times. He did not comply.
How much money he gave you?
My lord, 48 lakhs.
48 lakhs.
48 lakhs, and 2 lakhs already I have repaid. Thereafter, my lord, they did not, my lord, complied with me.
But where's a little different, my lord, little different. My lord, I am the my lord buyer. He executed a bainanama with me. In phases, I have been paying him money. The dates, my lord, range from April to August. I gave him 48 lakhs 50,000. And after receipt of this, immediately what he does, he executes a sale deed within 3 months.
No.
I did not say a word. On 30th of November 2023, he sells the property for 81 lakhs to one Mr. Alok Tiwari. I send him a legal notice. That is in December, immediately, that return my money. He transferred 2 lakhs out of 48 lakhs 50,000 and keeps quiet and does not pay up anything.
My mother was ill, so my
Let
money
him
is
return my
taken.
money. I have nothing more.
That's not the criminal case.
But the issue is what he has done, my lord, kindly see.
Yes.
The
Agreement for sale, he has breached an agreement for sale. That's all he has done. Petitioner submits. Very interested, huh? I will go to police station. Only work is recover money.
Now it has been transferred to DD. DD.
Because they filed writ.
They were not cooperative.
Post then the DD was
No, very powerful
before that.
de facto copy.
No, before that.
It has
No. After writ petition only.
Anti-cheating.
This is the, my lord, the order of the Honorable Writ Court.
Very good. Go to the Honorable Writ Court to get the bail cancelled. Yes, sir. Division bench. No.
Is there which?
Please. What is the case at its height? Breach of an agreement. Let him ask for specific performance or recovery of the money, the alternate pair. That's all. Petitioner submits. He is the owner of the property. De facto complainant entered into an agreement for sale but could not perform, but did not pay the entire sale consideration within the stipulated time. As he was in urgent need of money, he sold the property to a third party. He prays for and learned lawyer for the state opposed the prayer. Submits petitioner had dishonest sold the property and appropriated the money advanced. Learned lawyer for de facto complainant submit. Petitioner had entered into an agreement for sale. A sum over 48 lakhs was handed over to him, within 3 months. He entered into a sale agreement with another person. He sold the property to a third party. This demonstrates his dishonest intention. We have considered the materials on record. An agreement for sale was executed between the petitioner and de facto complainant. In terms of the said agreement, de facto complainant has paid a sum over rupees 48 lakhs. While petitioner contends he did not pay the remainder sale consideration, and due to pressing family needs, he sold the property to a third party. De facto complainant would argue petitioner dishonestly entered into the subsequent sale agreement. Allegations at its height disclose breach of contractual obligations arising from a sale agreement. Full stop. Recovery of money, it is not the purpose of investigation to ensure recovery of money in a contractual dispute. Full stop. Petitioner has pleaded due to pressing family needs, that is his mother's illness, he had to enter into the subsequent sale agreement. It is right, mere breach of contractual obligation per se would not infer existence of dishonest intention at the inception of the transaction. Under such circumstances, we are inclined to grant answer.
Grateful.
10,000 two sureties. Next.
My application. 420.
Item number 34, my lord, I'm praying for a day's accommodation, my lord.
For what?
My lord, we have received the case diary today itself, my lord. Praying for a day's accommodation, my lord.
420,409. I am the secretary of the society.
Secretary of the society.
My lord, from 2022, my lord, the inspection was done in the society.
17 lakhs due.
My lord, my lord, I have annexed the communication.
Tomorrow.
Grateful.
Secure that amount.
My lord, it is 17 crore.
17 crore. Then go to custody.
My lord.
I missed a zero. Or 2 zeros for that. Next.
May please, Your Lordship, 306. Lordship, the de facto complainant's husband had a extramarital affair with Lina B. Thereafter, husband committed suicide. De facto complainant, I am parents of Lina BB.
Said Lina was granted bail, my lord, by the learned court below. Father and mother of the Lina is before your lordship.
We have considered the materials on record. Victim had an illicit relation with one Nina.
Lina, Lina, Lina.
Lina BB. Petitioners are the parents.
Yes, parents.
Due to quarrel with Lina, he committed suicide. No, subsequently committed suicide. Petitioners are the parents of Lina and have been falsely implicated. Keeping in mind the extent of their complicity in the crime, Lina has been granted pre-arrest bail.
No bail.
Has been granted bail, keeping in regular bail, keeping in mind the extent of their complicity in the crime, we are inclined to grant answer.
Highly obliged.
Next.
My lord, I'm for the petitioner. My lord, there are 11 accused persons. Out of those, 8 accused persons have been released on bail by your lordship's order dated 6th of February 2020. My lord, I am the petition.
We have considered the materials on record. Petitioner is the husband.
Yes, my lord. I am the husband and the parents-in-laws.
Petitioner and the husband and parents-in-law of the victim lady. Allegations against them are general and omnibus. Allegation of abortion is not supported, forcible abortion is not supported by medical evidence. Under such circumstances, we are inclined to grant ancillary bail. Petition number 1 shall be investigating of
My lord.
consider we country further.
My lord, humbly, my lord, actually, I couldn't comply with the order passed by your lordships in my lord, in CRM A 298 of 2025. My lord, your lordships was pleased to grant bail upon the other accused persons. But I sent my client to take regular bail from the Chinsura court. Unfortunately, the learned lawyer from the Chinsura court has been registered and fully obstructed, strongly obstructed by the some of the lawyers of the Chinsura Bar Association.
Yes, next matter.
My lord, I am for the petitioner.
Well, I have instruction to appear on the de facto complaint.
Under 458, 376, Lordship, this is the service complete.
My lord, I'm in item number 40. My admission has been taken place on 4th of November 2024, Your Lordship. Your Lordship, out of 10 years, I've...
Once again.
My case is unmemorable. Previous day on 7th, Your Lordship, some sort of defect in certified copy. I submitted the lower court record has come here. So, my lord, I cannot seal it. Your Lordship admitted it, but it has.
There is delay in lodging first symptom. Delay in instituting the.
And also some seal was not in the backside of the.
All that. Copy of the petition is served about,
Section 5 application has been filed.
Filed is enough. Copy has to be served. Who has served? Who will serve? Where is your junior? Give a copy to Ms. Sinha. Having considered the averments in the application for condonation of delay, delay is condoned. appeal admitted, there are defects in the appeal as the trial court records have been received in connection with CRA DB 295 2020.
295. I'm 295.
Tariki. That's exactly what we are saying.
Yes, sir.
Trial court records have come in connection with your case.
Yes, sir.
Received in connection with so and so. The defects may be ignored. Full stop. Appeal admitted. Appeal admitted. Appeal shall be heard along with CRA DB 295 of 2020.
Lordship, may I want me to press my plan application, Your Lordship? Out of 10 years, because the petitioner in item number 39, he was awarded 15 years of sentence. My is only 10, Your Lordship. Out of 10, I have completed 8 years, Your Lordship.
What is the offense?
Offense is under section. I was convicted under section 20B2C, Your Lordship.
Narcotics.
I was out of.
Appellant as who is for bail application? 13 recorded not. In 40. In 40, who is appearing?
Sorry, in 40, I'm appearing for this.
All right.
39 has been served.
All right. Appellant has undergone substantial portion of the substantive sentence. That is, appellant has undergone imprisonment for 8 years. That is a substantial portion of the substantive sentence of 10 years. Though paper books are ready, there is little possibility of the appeal being heard in near future. Accordingly, in view of the aforesaid fact, in view of the delay, in view of the aforesaid fact, which as the protracted detention of the appellant infracts his fundamental right to speedy justice under Article 21, and in light of the law declared by the apex court in so and so, that suspension of sentence on the ground of protracted detention would not be hedged by restrictions under 37 of NDPS Act, we are inclined to suspend the sentence.
Deeply.
There.
Even there,
August. 8 years.
Custody.
Almost 8 years.
Next.
Item number 40.
I am appealing for the petitioner.
Very wrong.
My lord, restoration application of relaxation of
Oh,
condition of
restoration.
my lord, your lordship in earlier occasion to file a report.
Report complied.
Lordship charge submitted here.
All right. Restored. Report is placed on record. This time relatively. Now you are ready. Thank you. Condition of bail not to enter the jurisdiction. Where do you reside? Why do you want to go back to victim's residence?
My lord, I am residing at present. I am residing, my lord, elsewhere. That is the condition imposed. Serial number 5.
Now?
Serial number 5.
Only 6 months.
My lord, that is stated.
Not now.
My lord,
Investigation is in progress in view of the apprehension that petitioner may threaten the victim. And in view of the apprehension, though petitioner has complied with the condition was imposed upon the petitioner not to enter the jurisdiction where the victim resides. Investigation is still in progress, and there is apprehension that is there any threat perception of the victim? Achha.
still abscond. No, my lord. All are, my lord, are in custody.
1 second. Investigation is still in progress. Further report be filed whether there is any threat perception on the victim or not. Question the victim. If she has any threat perception, he will stay outside.
Yes.
All right. Adjourn 2 weeks.
Who is
Other matters 2 p.m. Mr. Mukherjee, which one?
my lord, instead of 2 weeks, 1 week.
1 week?
1 week.
One.
Great.
Yes.
First matter before Justice Boshak's bench, my matter is
All right.
fixed, my lord. If it can be taken up right now, who's the opposite party is there? 45.
45, who is there?
He's for the state, I'm for the appellant. If it can be, my lord.
What is the...
Yes, my lord, the sections 448, 326, 307, but the maximum punishment, life imprisonment is there, my lord. But I will show, my lord, that the identity of the miscreant was never brought on record.
Appellant contends that appellant contends that the identity of the assailant had not been established.
Yes.
What was the nature of injury?
My lord, 3 of the fingers were amputated and certain injuries on the face. At
All
night,
right.
in the darkness.
The injuries were on the hand. Injuries were primarily on the hand, a non-vital part of the body. There was no intention to commit murder. He prays for, he was on
I was on bail.
bail during trial and did not misuse liberty. He prays for suspension of sentence. And a lawyer for the state submits petitioner had caused, appellant had caused injury on the face as well as on the fingers. Offending weapon was recovered on the showing of the appellant. We have considered the materials on record. Injuries were on the, though three fingers have been amputated, the injury is primarily on the hand, a non-vital part of the body. It is to be appreciated on the evidence on record whether the appellant, during hearing of the appeal, whether the appellant intended to murder the victim. Appellant has made out an arguable case in appeal. He was on bail during trial and did not misuse his liberty. Accordingly, he prays for suspension.
I'm grateful.
Accordingly, his prayer for suspension of sentence.
I'm grateful.
Yes, 44, who is there?
I am
Six to 48.
Lordship 46. I am for the appeal. Your Lordship fix the matter today for final hearing and last occasion inform.
Lordship, 47, I'm for the appellant, but Lordship, it's a 2015 matter. We
So
tried to connect with the client, but Lordship, we don't have any brief.
forget connection. Let us connect ourselves.
Lordship, not even we have the brief. If your Lordship kindly send administrative notice to the.
No administrative notice. All those arguments before other benches. Okay. No admin. You get collect you to at 2 p.m. we are keeping. We will hear the matter.
Instead of today 2 p.m. because today 2 p.m. also I have matter at tomorrow.
Not today. Get the paper book. And
Not
who is
prepared. Lordship directed us to go to the LCR.
all right? Then let us have the paper books prepared. Huh? And who is 48?
48 also Lordship is subject to correction infractuous application because
Oh, double.
CRR well he was
This is a CRR.
CRR.
So paper books be prepared and placed before this court on the adjourned date, adjourned 4 weeks.
So I am already in custody subject to correction 9 years, 4 months out of 10 years. That is why you
4 weeks we have asked.
That is why you
What is the section?
304 part 2 conviction.
All right, not today.
Not today.
Examine the records.
I will give him.
Is she on bail?
She is on bail.
Lordship,
Then she will go under. If 304 part 2 comes, both of you assaulted, or you were the principal?
No, Lordship, there are 4 eyewitness. 2 eyewitness named other person we are present. Not other 2 eyewitness named along other me as an assailant. Another eyewitness along other named him as an assailant.
All right. Paper books within 4 weeks. We shouldn't be harsh towards her client.
great.
Contact your client in the meantime.
Grateful.
Yes. Next.
Well, 49, I am for the appellant, my lord.
53 টা কি?
Claiming juvenility বলো।
53, Your Lordship took the matter yesterday. My lord, I was claiming juvenility in this matter, my lord, case of 2003.
Which was state? Is what documents, please give a report. Report be placed, appellant's content, they were juvenile, they were minor at the time of occurrence. They have relied on certain documents, report be filed, adjourned 2 weeks. State shall submit report. Let them file. Then we will send them for inquiry. If prima facie there is credence, then we'll send for inquiry. Otherwise, no. Yes, 54, Mrs. Ghosh. 54.
54, my lord, I am for the appellant, my lord. Appellant number 125 has been convicted under section 326, 307, 320, 34, 10 years rigorous imprisonment and 10,000 rupees fine, my lord.
You were
I-
on bail.
Petitioners all along was on bail.
Appellants
Hey,
have been
appellants.
sentenced to term imprisonment. They were on bail during trial. No aggravating circumstance is placed on record. In view of the aforesaid facts and law declared in Bhagwan Gosai Shinde, we are inclined to suspend.
Grateful, my lord.
Well, I'm so sorry to disturb your lordships and embarrass myself also. But your lordships have been pleased to direct Millard, the Home Secretary, to appear tomorrow, Millard, personally. Millard, let me tell you, lordship, one thing. What surprises me is that there were two learned advocates who did not say a single word as to what steps I had taken. I mean, I personally, to ensure that these posts are filled up at least 10 days before the matter was before your lordships. Number one. Number two is the other gentleman who had informed the court that he had informed me. With respect, my lord, no information was given to me personally. Had the information been given to me, I could have come at 1:15 and requested your lordship to take it up on some other day because
That is what we recorded in the order.
yes, because
before rising you could have indicated.
yes, because two division bench, my lord, broke to hear an assigned matter in which I was on legs on the previous day. Therefore, my lord, I couldn't come.
That is
My lord, I got an SMS from Mr. Supratim Dhar.
You would appreciate also the difficulty of the honorable chairman.
Yes, I'll tell you, lordship. I'll tell you, lordship.
Harassment of the bench.
My lord, everything,
We are requesting
everything was
someone to
yes.
give assist. made an application before the Honorable Chief Justice?
Not assigned.
May I just tell you what has happened? It was not hard in part. But what has happened? They made an application before the Honorable Chief Justice. The matter was extensively heard by the bench presided over Justice Bag. Time by next month. Next month, more time. We will have more time. Why? No. You see what happens. Nothing will be happen. What? We'll have more time. No, it appear on Friday month. बेहतर होगा आपको सुनने entire day सुनेगा. No, better to be super my to be let it be keep you in suspense. Friday to be mentioned. Yes, to be mentioned. I don't want to be remembered anyway. Friday. Don't worry. Don't leave Calcutta.
Yeah, yeah.
Yes. Calcutta is a good place. No, why? His Lordship is part of and we love you very much. His Lordship. Best. His Lordship will not leave Calcutta. Why should leave love lies? Now sometimes some thing in here. Don't leave. We are very good man. We are not bad man. Mr. Bandyopadhyay.
I think Mr. Bandyopadhyay, in 1.5 years, I have realized that the bar is very, very good. I thoroughly enjoy my time.
You are also nice man. Very good. And Dilip advocate speaks about you also. We are missing. They are saying they are missing. I don't know. We are gaining. Not to? No, certainly. Right. Deep love, less mallet.
Not our
I know.
India, every court in India is worthy of our service.
Of certainly. But sometimes we fall in love with some others. That you losses cannot ignore. We fall in love. No.
We do our duty.
Huh?
We do our duty.
Make ourselves welcome to the bar. So that we are all from the bar. We know the bar. It's not that we dropped from heaven on trouble the lawyers have.
Yes, sir.
It's a mutual admiration.
Yes, absolutely.
And we expect
no one, we can't remain without one side.
For myself, I feel being a judge anywhere is the same. Be a judge in Calcutta, you be a judge in Chennai, you be a judge in Delhi. It's the same. And bar also is more or less the same.
Yes.
Expectations of the bar is the same. The positive aspects of the bar is the same. Challenges in the bar are the same. How do you handle the bar?
That's it.
Your ability. Thank you.
Thank you. We're grateful to us. Kire, পড়াশোনা তো করছিস না?
Yes. Next matter.
Item 55.
Item 55 led by Ms. Ashama Mandla. She is appearing through PC.
Yes. Yes.
Pursuant to your lordship's.
Yes, Ms. Mandla, you can commence your arguments.
Please, Millets. Millets, pursuant to your lordship's queries, Millets, we prepared a small updated note for your lordships. If I just may take your lordship to through 2 pages in that note. And Millets, it will be significantly clear, Millets, even on the medical evidence, Millets. Millets, my learned colleague in court has those documents for your lordships, Millets, along with a small case compilation for your lordship.
To the other side. Give to the copies also to the
Millets, in this, Millets, if I may please request your lordships to advert to page number 2, Millets, of the note, Millets, please.
Yes.
Millets, where it starts with Millets, material discrepancies. Millets, the first thing is, Millets, as we pointed out, Millets, even on the last occasion, Millets, that even in the complaint, the de facto complainant, the father said he did not rule out the possibility of suicide, Millets. Millards, that apart, PW 21, who's actually the post-mortem doctor, Millards, he says it's a case of simple hanging. Millards, there's a judgment of Supreme Court, Millards.
We point.
I apologize, Millards. Millards, page number 2 for your lordships, Millards.
Okay. Yeah. Page 2. Just look.
Right.
Millards, the PW 21 Millards had stated, Millards, that he could not come to a conclusive determination on the cause of death unless the viscera comes back, Millards. The viscera was never collected, Millards, in the present case. However, Millards, it was ruled as a case of simple hanging. Millards, with that, Millards, there's a judgment of the Honorable Apex Court called Piara Singh, Millards. We've quoted that. We've also placed that in the compilation for your lordships at serial number 1, which says that, Millards, when there is any kind of, Millards, difference of opinion between two medical experts, the one of the post-mortem doctor has to be preferred, Millards. Millards, that apart, Millards, on the last occasion, your lordship had pointed out, Millards, very rightly, Millards, that the ligature mark, Millards, is described as continuous. However, Millards, there's something very peculiar about this, Millards. Your lordship may please, in the note, Millards, please have, Millards, page number 3, point number 2, Millards. Because, Millards, even as per Modi's description of strangulation, Millards, must be continuous and, Millards, must be low down in the neck. This is, Millards, continuous and high up in the neck, Millards. Millards, there are some judgments, Millards, and medical reports, Millards, that we've placed on record to show your lordship. If your lordship may permit me, I'll take your lordship to the compilation. Millards, the body was suspended in the air for 8 hours. The time of death, as per the deposition of the de facto complainant, PW7, Millards, is of 9 o'clock to 9:15 in the morning. Then PW7, Millards, also states that the body was taken down only at 5:15 in the evening. The body remained suspended for 8 hours, Millards. Millards, there is research, Millards, even Millards Modi on medical jurisprudence, as well as quoted within Millards Apex Court judgments and research journals, Millards, states that the ligature mark formation, Millards, also depends on the time, Millards, the body was suspended after hanging, Millards. Millards, even Millards, the deposition, there is one more thing, Millards, which I have to point out to your lordship before I start showing your lordship the compilation. Millards, on the last occasion, subject to correction by Millards, the 311 application, Millards, in the TCR, Millards, that is for the IO. The second IO, Millards, who took in the requisition of the report from the second doctor. And Millards, the second IO who continued investigation despite summons did not even appear before the learned trial court. With that, Millards, if I may just be permitted to now show your lordships the post-mortem report for a moment, Millards, along with PW 21's description and a comparative chart to Modi and just 2 judgments, Millards. Then I'm in your lordship's hands so far as, Millards, the ligature mark is concerned, Millards.
Yes.
Please, Millards. Millards, in the note at page number 4, Millards, we have reiterated, Millards, we've pasted the chart from Modi's medical jurisprudence on hanging and strangulation, Millards. Millards, with that, if I may just please request your lordships to have page number 62, Millards, of the paper book, Millards. This is where the description of the ligature has been given, Millards. 62, Millards, PW 21's deposition.
Yes.
Please, Millards. Millards, at page 62, Millards, where it at the bottom of the page, Millards, where it says following external injuries were noticed, Millards. In the neck, one continuous superficial abrasion, ligature mark with ecchymosis surrounding the mark present high up in the neck. Now, Millards, insofar as, Millards, Modi on medical jurisprudence, your lordship has that table, Millards. At point number 4 of the table, Millards, for hanging, it says ligature mark oblique, non-continuous, high up in the neck. My lords, for strangulation, it says ligature mark horizontal or transverse, continuous around the neck, low down in the neck. So, my lords, over here in the present case, even though it is continuous, but it's high up in the neck. So, my lords, it's foiling in strangulation as well as in hanging. Then, my lords, it also, my lords, I'll read further from page 62. It also says, my lords, encircling whole of the neck, sparing a small area over the back, just behind the left ear, the mark horizontally placed and obliquely placed on sides. So, my lords, as per even the description again in Modi, horizontal is in strangulation, oblique is, my lords, in hanging. So, my lords, even PW22's own report is not consistent with medical jurisprudence, my lords. Because, my lords, the only explanation perhaps, my lords, could be that continuous was due to the duration of suspension, my lords. Because otherwise, my lords, consistently, Supreme Court has also held, my lords, in a spate of cases, my lords, that for strangulation, it must be low down in the neck. High up is always hanging, my lords. In the present case, it's high up, my lords. With that, my lords, if your lordship may permit me to please place on record 2 judgments for your lordship's perusal, my lords. And my lords, one more thing, I'm sorry. My lords, just while your lordship is at page at PW 21's deposition, my lords, at page number 63, my lords, when the cross-examination starts, my lords, at the bottom of the page, my lords, PW 21 also admits that with regard to injuries 2 to 9, which are on the elbows, knees, and back of, my lords, the deceased, my lords, he says, my lords, she says, I have not said about the age of the injury. So, my lords, though injuries are noted, they are noted as ante-mortem. However, my lords, the age of the injuries is not there anywhere on the post-mortem report either, my lords. My lords, if I may just take your lordship to the judgment, my lords, of the apex court on these 2 points, my lords. My lords. Lordship, the first judgment is of Piara Singh, my lords. In the compilation, it starts at page number 1, my lords.
Right.
The relevant paragraph is, my lords, para 6.
That's what I told her, no, the person who sees the injury.
Yes, second
You are seeing that problem.
You are
Is, it is the findings, the opinion of the hanging. Is
No,
a
no, 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 it is not.
merged with the findings. Very conclusive opinion of simple hanging. Injuries on other parts of the body. Continuous ligature. It's a contraindicative of hanging. They've said that I'm not sure whether it is hanging or strangulation. To say simple hanging, pushing it a bit too far. Yes.
Please, my lords. Your lordship may please have para 6 at page number 6 of the compilation, my lords. In Piara Singh, my lords.
Achha. Yes.
My lords. Page number 6, para 6, my lords.
Right. Para 6.
Please, my lords. We find ourselves in complete agreement with the observations made by Calcutta High Court in the aforesaid case and hold that where the opinion of a medical witness is contradicted by another medical witness, both of whom are equally competent to form an opinion, the opinion of that expert should be accepted, which supports the direct evidence in the case. Apart from this, in the instant case, it appears that Dr. Jatendra Singh had the initial advantage of examining the deceased and holding his post-mortem and observing the nature of injuries on the body of the deceased. His opinion is therefore is based on the first-hand knowledge and would be in any event preferable to Dr. Paramjeet Singh, who did not have the advantage of seeing the deceased or the injuries on his body, but deposed purely on the basis of description of injuries given by Dr. Jatendra Singh. For these reasons, we therefore we do not prefer the evidence of Dr. Jadendra Singh to the evidence of Dr. Paranjeet Singh. It is true that the High Court has relied on a number of books on medical jurisprudence to support the evidence of Dr. Jatendra Singh. We find it was not necessary for High Court to do so unless the books were put to the expert. Recitals in books do not provide a sufficient guide to determine the truth or falsity of testimony of an expert. So, it's only this relevant one paragraph, that preference, to the postmortem Dr. Millets. Thereafter, the Honorable Supreme Court, in the judgment of State of Rajasthan versus Ramesh, which is, starting at page number 9 of your Lordship's compilation, just one paragraph, para 17, for your Lordship's perusal, which is at running page number 14, para 17, running page 14, bottom of the page, Lordship has that. Minutes. According to Modi's medical jurisprudence and toxicology, ligature mark depends on the nature and position of ligature used and the time of suspension of body after death. If ligature is soft and the body may be cut down from ligature immediately after that, there may be no mark. This is only to support the point that for 8 hours the body was admittedly left hanging on the fan because there was no magistrate available for the inquest report at that time.
Not make a mark which is non-continuous, continuous.
I bowed on but all the research on continuous and non-continuous is only coming down to that also the duration also depends. But because high up and low down. Please,
The actual submission with regard to the ligature mark being high up on the neck,
please,
being lower on the neck,
please,
and the absence of fracture of the hyoid and trachea bones or the trachea.
Please,
but the other judgment, that's the one that you're citing,
please,
it's a judgment in relation to absence of ligature mark in cases of asphyxial death because of the nature of the ligature.
Please, please,
a soft ligature, it may not leave behind a mark.
Please, I bow down. Just one last paragraph, in one judgment, and then I'm in your Lordship's hands so far as this point is concerned.
Which paragraph you rely on?
The next judgment of Satish Nirankari, para 38, page number 36, running page 36, para 38,
How? Page 17 you want. Satish.
Page 36, para 38,
Miss Banla, I think there's one judgment. Sometimes in 2022,
please,
a circumstantial evidence case, if the cause of death is unclear, then the benefit goes to the accused.
Please, two possible views, the one favoring the accused.
That is a judgment delivered by Justice Oka.
Please,
it is in respect of 498A and 302 where the courts were drawing an inference under 106 of the Evidence Act. And that the foundational fact for 106 being a homicidal death must be proved beyond doubt.
Please, your Lordship had pointed out, on the last occasion, I read the judgment for your Lordship.
Judgment is not there. That's
why. I'll just get it. I apologize, I'll just get that also, My deepest apologies. I'll just have Miss Ritu bring it for your Lordships in the next 5 minutes.
Was lazy. I did not bring out.
No, it's my mistake, for not putting it.
That's a very interesting judgment. And I think it's just to cover your. It says that cause of death must be proved as homicide if you are to bring in 106 as a ground to convict him under 302. It's another thing if you convict under 304B, then unnatural death is good enough. But if you convict under 302, you must establish the cause of death here. And if you have some doubt with regard to cause of death, then under 302, just by inference, you look into, we have followed your submission on this.
Please,
And next judgment paragraph, which you are 38, 39, you are relying, right?
Please,
Okay.
In this also, if I may be permitted to just read para 38 minutes. Coming to the cause of death, the learned counsel for appellant had argued before us as well as in High Court that as per Modi's medical jurisprudence, there are 16 main distinctions in death caused by hanging on strangulation. According to medical evidence, second ligature mark was to ending towards back of the neck and it was oblique going upwards and ligature mark was shining. The hyoid bone was intact. There was no...
These are facts. No, they carry you, they don't carry you. In 2015, there were no abrasions. In your case, there are multiple abrasions on the face and other parts of the body.
It's not clear.
Please, minutes.
What we feel the best argument subject to hearing the state maybe if there's a dichotomy and some confusion with regard to cause of death, they drag in a person and convict on 106 may be hazardous.
Please, minutes.
Because we must apply the presumption of adverse inference on certain facts which are proved indisputably. And if the fact is not put indisputably, it may be dangerous.
Please, minutes.
We would like you to address us on this.
Please, minutes.
All right. For Ms. Mandla, matter is fixed. Next Wednesday we will keep.
Next Wednesday, as per your lordship's discretion.
Next Wednesday.
Next witness.
You were charged with 304B also.
Please, minutes. Initially, minutes, the FIR was under 306 and 304B. Then, charges were framed under 302 and 304B. And then, conviction took place in 302.
A graver charge you have been convicted.
Please, minutes.
All right.
We are equipped with HON'BLE. The judgment passed by your lordship. With regard to the opinion, which will prevail? The postmortem
You
doctor...
show us
Yes,
that.
Dr. HON'BLE, your lordship has held that the case in respect of the postmortem doctor has not been quashed by your lordship in 2016. I have showed your lordship judgment.
The law, as she demonstrated, is you give credence to the doctor who actually does the postmortem. But in certain cases where the findings of the doctor are not in sync with the proposition of medical jurisprudence, but the opinion of another doctor is more nearer to the principles of jurisprudence, what do you do? Do you rely on the subsequent doctor or do you give the benefit of the doubt? And because here you don't have direct evidence as to who murdered.
We can satisfy your lordship from Exhibit 20. I've checked the record. Exhibit 20.
And another thing which we pointed out, there was a 311 application also
Yes.
calling for the doctor, IO to produce the doctor.
IO. But the IO was not examined.
But how?
Subject to the correction.
The doctor was examined previously and only thereafter, my lord, the 311 of petition was filed by the prosecution. But I've gone through the
You've
order.
gone through. Please demonstrate that.
My lord.
How was the doctor summoned? Who summoned the doctor?
My lord.
Who summoned the doctor?
That is
Because he was not a witness in the charge sheet. Right.
My lord.
Later we will
Come back on next Wednesday.
later next Wednesday we are keeping it. All
Please,
right.
Yes, because even in the 311 that your lordship perused.
We have taken in consideration your submission. That it relates to the doctor, it relates to the second IO.
Please, minutes. And even he didn't come.
Of the doctor, but the second IO has not been examined.
No minutes. He didn't come despite summons.
I'm grateful, madam.
Grateful.
Deep to pledge minutes.
Roy Chaudhary, 59.
In 58, I'm
Amitabh,
59, I'm for that.
you have now come into appeal also. Kerosene tel over. Here only kerosene oil is used for burning brides, not for dealers to supply to like ration card holders. He's only kerosene oil dealer. Yes. Others are there? The main, you are for the main appeal.
No. I'm for Khoirul.
Who is appearing for the others?
CR is 612. I'm representing.
Mr.
And
Sinha was
Mr.
advancing
Abhishek
the-
Sinha is
Where
for
is
the-
Mr. Sinha?
He's
busy.
on his way.
Miss Sinha. The one Sinha is as good as the other. You are not appearing for the state in this matter.
No, sir. Miss Gaur is appearing.
Hmm.
56.
We are keeping it on another day. Which will your convenient day tell us? Any day, sir, because today we will rise in half an hour. So we don't want to keep hearing this one. Commence the hearing. The other hearing is going on. We'll finish it and then we'll take up this one. So, কবে একটা ডেট দাও না 26 না কত বলে না তাহলে মার্চে দিয়ে দেবে Can we keep this on 4th of March? Mr. Sinha, 4th of March?
4th of March, I'll be out of station. 4th to 8th.
How I could, read your mind and select 5th of March. You will be back in session
4th to 8th. After 8th.
10th. 10th of
Okay.
March. Sure.
Great.